Well, the theme for tonight's gathering is how women can change the world. And the year's global theme, as designed by a UN committee, is equal rights, equal opportunities, progress for all. So what I want to do is to address both those themes, how women can change the world and equal rights, equal opportunities, by focusing on the way that international law can help women change the world by achieving equal rights and equal opportunities. And I want to just focus on one part of international law that's relevant here, and that's the 1979 Convention on the Elimination of All Forms of Discrimination Against Women, which was adopted by the UN General Assembly, as I've said, in 1979. What the convention does, and it's worthwhile just looking at it, you can easily get it on the web, it's quite a short convention and written quite clearly. It makes countries that have signed up to it undertake a simple pledge to accept to end discrimination against women. Now, it defines discrimination in very broad terms. It says discrimination means any behaviour that has either the purpose or the effect of denying women their human rights. In other words, and this is quite important, it covers both intentional and unintentional forms of discrimination. And I think here in Australia, we're often battling the effects of unintentional discrimination rather than intentional discrimination. So the Women's Convention, as I'll call it, requires countries who accept it to take legal and other methods to ensure the practical realisation of the principle of sex equality. And the convention's very broad. It talks about a whole range of areas where countries who sign on to it should take action: political and public life, international organisations, education, employment, health, financial credit, cultural life, the rural sector, and the law. This treaty is then set up and it's monitored by a committee known as the Committee on the Elimination of Discrimination Against Women, which is comprised of 23 experts. There's no Australian serving on that committee, but Elizabeth Evatt, a really very important person in law and indeed the public world for Australia, she actually chaired this committee for many years. Well, this convention, the Women's Convention, has a great number of countries that have signed on to it. In fact, it's 186. And if you think there are 192 members of the UN and this treaty has got 186 countries signing on to it, that's a fairly impressive figure. The most recent country to sign on to it is the country of Qatar just last year in 2009. Here in Australia, Australia became party to this treaty in 1983. The most striking country that isn't yet a party to the treaty is the United States, where there's deep political controversy about any form of international scrutiny of human rights, so the US is not a party to it. Well, it's all very well to have these nicely worded treaties, but how do human rights treaties work, and do they work? Are they actually effective in combating inequality and discrimination? How can they help women change the world? We know, of course, there's no international police force to help us implement these treaties, so how do they work? Well, I want to mention 3 different ways that the treaty works. One really important way is that the Women's Convention what it does is to provide the basis for national laws. So here in Australia, our Sex Discrimination Act, the Federal Sex Discrimination Act, adopted in 1984, is really based on the CEDAW Convention. The Australian government, under our Constitution, wouldn't have had the power to enact such a law unless it came from an international treaty. What's interesting is the Sex Discrimination Act is in some respects wider than the treaty and in some respects narrower than the treaty. It's wider than the treaty because the Sex Discrimination Act applies to men as well as to women. So men in Australia can use the Sex Discrimination Act to complain about discrimination against them on the basis of that they are men. And the Women's Convention only applies to women. So that's one way that it's broader than the treaty. But it's also narrower because our Sex Discrimination Act allows various activities to be exempt from its scope, both temporarily and permanently. Just one example of a permanent exemption in the Sex Discrimination Act is the provisions that allow discrimination by religious bodies in ordaining, appointing and training priests, ministers and participants in religion, and many religious activities are exempt from having to observe the principle of sex equality. Religious educational institutions also are allowed to discriminate on the basis of sex in the employment of staff. Well, countries can actually opt out of some of the terms of the Women's Treaty by making a formal reservation to its terms. So you can say, yes, we'll be a party to this treaty, but we object to some of the provisions in it or don't think we can live up to them yet. And Australia actually, when we signed and ratified in 1983, we've made 2 reservations to the treaty. One excludes women from combat duties in the armed forces, and the other states that Australia is not in a position to provide a comprehensive maternity leave scheme. I hope that Australia will soon move to remove both of those reservations. And given that now it seems both sides of politics are supporting a paid maternity leave scheme, perhaps that will be possible. Those are Australia's reservations, but some countries have much, much more substantial reservations. And I was quite struck by looking at the reservations of the newest member of the treaty, Qatar, who, as I've said, became a party to the treaty last year. When it accepted the convention last year, Qatar carved out some really serious exemptions to the treaty terms. For example, it stated, yes, we'll sign on to the principle of women's equality. However, we do not accept provisions that women should be equal with men before the law with respect to inheritance laws, because in Qatar, men have priority in inheritance. And also, men's testimony under Qatari law is given more weight than a woman's testimony. If you're a man, your testimony is accepted. You need 3 women to equal 1 man in terms of their testimony. So Qatar has done the rather bizarre thing of saying, we accept this treaty, except we want to preserve these discriminations in our law. Also, Qatar didn't accept that women should have the same rights to enter the marriage as men, nor that women should have the same rights as men during a marriage or once the marriage has ended, or equal rights with men with respect to custody of children. Now, while there's just no question from an international legal perspective that this type of reservation is invalid at international law because it undermines the object and purpose of the treaty, the trouble is there are no satisfactory mechanisms at international law to challenge those sorts of reservations. There is provision for countries to object to the reservations, but I was struck that no country has yet objected to Qatar's reservations. And under UN law, you've got exactly a year to object, and Qatar made its reservation last April. So there's 3 weeks more for some countries to actually make an objection to that reservation. So that's one way that the Women's Convention, it sets national legal standards, although not always perfectly, as we've seen. Another important way that the Women's Convention can support women's equality is that it provides a mechanism through its optional protocol for individuals to bring cases of really serious sex discrimination to the attention of the UN Committee. Now, although the committee doesn't have direct enforcement powers, its views actually can put considerable pressure on countries to amend their laws and practices. I just want to give 2 examples of cases that have been brought under the optional protocol. One was a case in 2006 involving Hungary. A Roma woman who was the mother of 3 children was pregnant, her fetus died, and she was taken to hospital for a caesarean. And at the hospital in Hungary, the doctor gave her just a slip of paper as she walked in with the Latin word for sterilisation written on it. And she signed that, not understanding Latin. And she only discovered what had happened to her when she asked the doctor when she could try again to have another child. Now, she'd actually used the Hungarian court system, but the Hungarian court system said, well, the doctors might have been negligent, but they would not give her any compensation because they said that she could prove no lasting handicap from the procedure. Not being able to have children wasn't, in their view, a handicap. So, in the end, a group of Hungarian women's NGOs took the case to the UN Women's Committee and argued that this breached the provision in the Women's Treaty, which Hungary had signed, requiring equality in healthcare and access to information. And Hungary had to appear before this committee, and it simply said, well, this woman hasn't suffered any damage, she's already got 3 children, so what's she complaining about? But the CEDAW committee went on to find that this was a clear breach of the convention and that Hungary had violated its duties. They actually found that there was 17 minutes from the time of this woman's admission to hospital to her sterilisation. And they said, therefore, it was pretty clear that there was no plausible case for counselling to have occurred. And this then resulted in legal and administrative changes in Hungary.